Hi there, everyone. It's Rob Ryder. Today is Wednesday, January 16th, 2019. And we're going to be talking about buyers and sellers and brokers and insurers. Lend me your ear. These are all like the parties that are involved in your real estate transaction. And so, if you use the services of a licensed real estate agent to buy a house, then the real estate broker, your agent, or his or her employer, depending on who's got the higher license, right? We're looking for the higher licensed person, has a duty to render an account of the entire transaction. You have a common law agency relationship with that licensed agent or broker. So under agency, then under contracts, an agreement which is express or implied by which one of the parties, called the principal, confides to the other, dominated the agent, the management of some business to be transacted in his name, on his account, and by which the agent assumes to do the business and to render an account of it. So the whole transaction in a real estate transaction is the duty of the broker. And that's to make sure you get a good title. So I did a video just a few days ago, just on the weekend. Real estate broker is buyer's negligent fiduciary agent. This video I'm doing now is kind of a follow-up to it. With the idea being that I'm going to show you a bunch of different forms from different states, give you an idea what a buy-sell agreement looks like. That, at the end of the day, that's what you went to the broker for. You wanted to buy a house. Then you're going to sign a broker's agreement and make them your broker. And then you may sign a buy-sell agreement between you and whatever house it is you're trying to buy, right, with the seller. And those are the controlling documents in the purchase of the house, right? So now, those are supposed to be recorded, it looks like, in the county records. But when you go to the county and you look in the property file, you don't find a buy-sell agreement between the buyer and the seller. You find a thing called a warranty deed or some similar word. That's the title. Although when you actually read it, it isn't a warranty deed. It's just titled a warranty deed. And maybe a deed of trust or who knows what other documents. But none of those say buyer or seller. None of those have anybody's full legal name on them, right? First name, middle name, last name, no initials, no nicknames. And so they don't have any standing in law because, they're illegal, right? You got to use your legal name in legal matters. Well, that would be the law. So, there's always been something fishy going on, but the problem is anybody in a foreclosure, you need to go see your agent. Quit going to the court and so forth because that's not where the problem is. The problem's over with the agent. And for whatever reason, right, you don't have a good title. Well, make it your agent's responsibility and have him go fix the problem. Or it's errors and omissions time. So, documents filed in the public record evidence that a breach of contract exists, requiring immediate action by your agent. Or you're filing for mediation with the local Realtors Association, about the agent. This video may help you determine the evidence of error or omission is in the public record, what information the broker has available, and what to do with both. So we're going to look at some documents, say, okay, well, this is wrong or this is wrong, and here's your evidence of errors and omission. Now take this to the broker and find out what's going on and have him finish the deal. And I believe what we're going to find is that the realtors, that group, is the right hand, and the title insurance is the left hand. The right hand doesn't know what the left hand is doing. And by that, I mean things like this. So let us look at some documents for somebody's property. So this, calls itself a warranty deed. And I showed this in my video, the last video I did. But here in the, blah, 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 it doesn't say it's a warranty deed. If it was done properly in Arizona, this statement here, does hereby convey, it would say something like, does hereby warrant and convey. That would make it a warranty deed. Not the fact that somebody put some words up here and said that it is. Right? So this isn't a warranty deed, number one. And that's how they're supposed to transfer the title, is by a warranty deed, which conveys and warrants the title. And the parties aren't, real parties in interest, because Dustin S. Axtell, a married man who acquired title as Dustin S. Axtell, a single man, isn't anybody's name. Right? It's not an I or a we. This is a fiction. Dustin S. Axtell isn't somebody's full legal name. Neither is Jeffrey S. Jacobs, an unmarried man. That is a legal fiction. It's a thing. It isn't a man. Right? So, now neither of these say buyer or seller. So it's like, well, who are these people? And they're pretending to have something to do with a piece of property. But hey, this is theirs, right? So if what Jeff did is he went down and looked in his property file with the county and, got out all the papers. Well, this is one of them. But this doesn't prove that he owns the property. Now, he also has a non-assumable loan, so they say. But this doesn't show that it's been recorded anywhere. There's nothing up here to show it's been recorded. And in Jeff's case, he was in the military, so they can't be changing the people who you borrowed the money from. Right? Borrower promises to pay Nova Financial and Investment Corporation, comma, an Arizona corporation. Well, again, that's a legal fiction. That isn't the name of Nova Financial and Investment Corporation. It could have been if they'd stopped there, but they added the rest of this on and they created a legal fiction. And how did he do his? Right? Jeffrey S. Jacobs. Well, he's not. Jeffrey S. Jacobs doesn't exist. He's not a real party of interest. In all contracts, in all official matters, you need to use your legal name. Here's the deed of trust. That's what I want to look at. Now here's the deed of trust to the same one, right? Where it says the borrower is Jeffrey S. Jacobs, an unmarried man. Well, again, that isn't anybody's legal name. And where this could be the name of the lender, on the note, they put comma, an Arizona corporation. Well, that isn't how they did it here. They put a period. Well, a period and a comma aren't the same thing, right? This is all, I know it's all smoke and mirrors, but it's done on purpose to be that way. So this deed of trust doesn't have any validity. I mean, this isn't the name of the buyer. So as we'll see, a lot of this information we would find also on the buy-sell agreement. But none of these are the buy-sell agreement. We haven't found that yet. We've seen a deed of trust. We've seen a warranty deed. We've seen a non-assumable note. We're going to look at the homeowner's title insurance, right, from Old Republic National Title Insurance Company, which says your title insurance policy is a legal contract between you and us. And the parts that it has in. All right, signed off by the agent, signed and countersigned by the insurance company. Goes through all the things that are covered risk. Hey, your title is defective. Well, we're going to find, I showed that in the other video. These things are what's happening. But on the actual page where it shows, well, who was insured, which is the Schedule A, it shows that the insured is Jeffrey S. Jacobs. Well, again, he doesn't exist. Right? And there isn't any comma, a single man. So this isn't the same Jeffrey S. Jacobs that was on the warranty deed. or the deed of trust, right? Because that was comma, an unmarried man or something like that. So this owner's insurance policy is something that was supposed to have been done by the seller on behalf of the buyer. And therefore, the fact that this doesn't have Jeff's full legal name in it is the seller's fault. Hey, he was also probably, or would have been, represented by an agent. So this is the paperwork that's normally found if you were going to go into a foreclosure, or you went down and looked in your records yourself, that you would find that are going to be part of the deal we're talking about. And that would mainly be the warranty deed and the deed of trust. Right? This homeowner's insurance, you're not going to find this in your record. You may have a copy of this. If it's in your record, they never put it into your court case as a foreclosure, right? But they do put the deed of trust in. And so this is an escrow number, right? So let's remember, this is an escrow number. And, I'm believing that the escrow is never really closed and everything is still in escrow. And the thing with agents is that an agent has control of the whole thing. There could be multiple agents, and any one of them has whole control of the transaction. So if we're not going to do this deal, then get me my money out of escrow is what I want the agent to do. So, but none of this paperwork came from the agent. That's the other thing, right? None of this came from the agent. It came from, I don't know who filled this out, the bank, closing agent, whoever it was. So, so before we go look at the paperwork that the realtor would do, let's just read a little bit about, their code of ethics and standards of practice of the National Association of Realtors. It's interesting, this word realtors, right? That's like .com. If you look on their site as .realtors, they have their own section of the internet. Where the word realtor is used in this code and preamble, it shall be deemed to include realtor associates. And so those would be people that the realtor hires to do the actual transaction for them, right? They're acting as your agent, but they may have other people do the work. So, right, they're still bound by this relationship that you have with the realtor. While the Code of Ethics establishes obligations may be higher than those mandated by law, in any instance where the Code of Ethics and the law conflict, the obligations of the law must take precedence. Well, that would make sense. Preamble. Under all is the land. Ain't that good to hear? Upon its wise utilization and widely allocated ownership depend the survival and growth of free institutions and of our civilization. And none of that's happening right now because you don't own your property because there's defects in your title. So we don't have this wide allocation of ownership. The ownership is in the hands of the few, and they keep every time just pretending to transfer title, but they never actually do it. And the evidence of that is, where's the transfer tax? To show that it's been canceled or paid. The receipt. More of that in a bit. Realtors should recognize that the interest of the nation and its citizens require the highest and best use of the land and the widest distribution of land ownership. They require the creation of adequate housing, the building of functioning cities, the development of productive industries and farms, and the preservation of healthful environment. Such interests impose obligations beyond those of ordinary commerce. They impose grave social responsibility and a patriotic duty to which the realtors should dedicate themselves, and for which they should be diligent in preparing themselves. Realtors, therefore, are zealous to maintain and improve the standards of their calling and share with their fellow realtors a common responsibility for its integrity and honor. And for that reason there, call your realtor and ask him for some paperwork from your transaction. We'll get into what that is in just a minute. But, they seem to take it serious. They're talking about they're dealing with the land. What they're dealing with the land, then we're dealing with common law. Right? It's not statutory. This is the land. And if it was English common law, we'd be dealing with the Court of Chancery, because they're the ones that have jurisdiction over the types of things we're talking about, where there's a defect in the record. We should be the owner, but there's a defect. Well, in common law, he who holds the property is the owner, or whose ever name it is the owner. And it isn't in your name. It should be in your name, but it isn't. To get that fixed, you have to go to the Court of Chancery and get them to call in the name of the owner and say, how come you haven't transferred the title? Right? You guys have a contract. It's the way common law works. So this National Association of Realtors, then, they have their own buyer-seller dispute resolution system. All right, the dispute resolution system. This program is designed to resolve disputes between buyers, sellers, and real estate brokers, salespeople. Well, that's what we have. Dispute resolution system and the acronym DRS are used to identify methods of resolving disputes out of court, including mediation and arbitration. And there are several types. I have to laugh. You got negotiation, mediation, arbitration. Negotiation. This would be go to your brother first. Mediation. This would be get 2 or 3 witnesses. Arbitration. That would be take it to the church. The next one would be take it to the civil court, which they don't have in here, but that's where it goes afterwards. Right, this is right out of the Bible. This is how you resolve a dispute. Go to your brother first. If that doesn't work, go get witnesses. If that doesn't work, go to the church. If that doesn't work, well, then take his ass to court. Now, the thing is, you won't be doing this, right? Your agent will be. They'll be negotiating, mediating, arbitrating. If they're going to do the right thing. I don't believe we need to do this with our agent. We need to do this with the other people that were involved, and our agent will be the one doing it for us. But this is the system they have in place. They don't have to go to court. Right? Faster than litigation, less expensive. Discourages frivolous claims. Provides a service brokers and salespersons can offer to clients and customers. Potential for lowering costs of errors and omissions. Parties retain their legal rights to arbitrate and litigate if mediation is unsuccessful. True interest of the parties are discovered and addressed. Right? A process helps restore goodwill between disputants. Da 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 da. Well, as we'll see, there's things that the seller was supposed to do, which, he may have done thinking they've been done, but they were done incorrectly, so they're his fault. And, well, your seller had a broker also. So they have these agents that can take care of all this for us, don't have to go to court. These materials were developed, It isn't that big a deal. It just gets down to, with few exceptions, almost any real estate dispute can be mediated under this program. Right? So you don't even have to have been to a realtor. Just take it to these people and have them do something. And these people is this National Association of Realtors, which, has state associations of realtors and then local associations of realtors. It's like it's its own system all by itself. They're all part of a voluntary association, and they've agreed to the terms. Any party may initiate mediation by completing, signing, and mailing to the association mediation provider, if already known, and to all other parties a request to initiate mediation transmittal form. See Appendix D. A request for mediation must include the following information to the extent known and readily available. Well, this is why you have an agent. They know all that information, right? They're going to mediate it for you, right? They're not your attorney. They're your advocate. Well, I won't say representing you. They're your agent. They're doing business on your behalf under your name. Okay, so I wanted to show you some styles of forms that they use, right? That from the broker's office, whether you've seen them or not, just to show evidence. Well, they do exist. And as soon as somebody took a commission, right? Well, you just gave them valuable consideration, and now they have a fiduciary duty, and they're just not done yet. So let's put them to work. Very good. Okay, hang on just a second. Okay. First of all, this is the website I was talking about, www.nar.realtor, right? National Association of Realtors. And if you go into this about NAR, you can find their history and the code of ethics I showed you, their governing documents. They have a constitution and bylaws, and you can know everything that they're supposed to do for you. And that's where it starts. What is somebody supposed to do for you? Right? Know what their job is. And then go show them, hey man, you got a duty. You got to do something for me. So let's look at some examples. Right, so this is a buyer agency tenant representation agreement, right? Buyer agency. Exclusive authority to act as buyer's agent. Client gives the firm and its agents the exclusive right to act as the buyer's agent and or tenant agent to locate an interest in property and to negotiate the acquisition of an interest in property for client, except as excluded under some lines. The client agrees during the term of this agreement. Client will not enter into any other agreements to retain any other buyer's agent. Now, I know we're talking about real estate. We think we're talking about houses. But I think these are the people you make your agent for you, because you have movable land. Right? Your body is dirt. It's land, soil. It's part of your inheritance from the Lord. He gave you that earthen vessel you have. So I'm wondering, well, the Bible says you're supposed to sell all your property and follow Jesus. Can I go to them and say, here's my Social Security account. Go ahead and sell that for me. And I'm going to go follow Jesus. Right? I don't want to have it in that account anymore. Go ahead and sell my account. Negotiate the property. I'm going to find out eventually. But right now we're going to work on houses. All right, let's start with the thing that we have, which is houses. But farther on, right, is this our registered agent that we're supposed to have in the, in the realty? Because they're working on the land, and that's what we're trying to get to. So, if you have an agreement like this with a broker, and then you could get this recorded in the public record, it would be record that they've agreed that you're in the United States. And right now, you're not in the United States, right? If you were in the United States, it wouldn't matter if you were a citizen, a national, a foreigner, anybody other than a criminal. You would be protected by the Constitution. And they're not using the Constitution to protect you. They're not using the Constitution at all. Many other videos I've done on that, but back to this, right? Client gives the firm and its agents the exclusive right to act as buyer's agent to locate an interest in property and to negotiate the acquisition of an interest in property for the client. And how are you going to compensate them? Well, by a commission. All right, so whether you sign one of these or not, if somebody says that you've paid them a commission, then you have an agency relationship with them. So I'm not going to get into too much detail on this. I'm just wanted to show you, well, there is an agreement that you can have with the buyer and the agent. Is this the same thing here? Here's one for Michigan. I think this is here. All right, exclusive buyer agency contract. Broker shall assist buyer in purchasing real estate as more particularly described in paragraph 2. Now, you think real estate is a term, but actually it's just two different words. And real would be tangible, estate, things you can put your hand on. An estate can be almost anything. So it doesn't have to be a house, it's just real estate. As opposed to real estate, a term, two words in their common law noun definition, real estate. Property, my social security account. Exclusive agent, buyer agrees that during the term of this agreement, any and all inquiries and or negotiations on behalf of the buyer related to the acquisition of any desired property shall be through the broker. And so they're going to get your mail. I don't know if I marked it on all of these different ones I looked at, but they are on all the different ones, right? Realtor and buyer, here's your, right? This is a contract, bilateral contract signed by both parties, not like your deed of trust that only you signed, that they're going to say is a covenant, like you promised to give it, like a gift and donation. No, they're saying it's a bilateral. These are bilateral contracts. Okay, so now that you've got a broker and you're going to go make an offer, which is really what this form is, it's the offer form, right? Licensee drafting this on is agent of the buyer or the seller, right? Whichever it is, the buyer. Now they're going to put your name, and so this is why we want to see this form. What name did they put for the buyer? Did they use your full legal name or not? Offers to purchase property known as at some street, purchase price, earnest money, balance, right? This is an offer. Well, at the end of the day, this thing was supposed to have been recorded and filled out and all sorts of things supposed to happen. But this is where the sneaky stuff starts. Delivery of documents and written notices. Unless otherwise stated in this offer, delivery of documents and written notices to the party shall be effective only when accomplished by one of the methods specified in lines 36 to 54. Isn't that nice? Every line's got a number. So personal delivery, giving a document or written notice personally to the party or party's recipient of delivery if named in 38 or 39. So what name, if you're the buyer, is here in line 39? That's who's getting your mail, right? Delivery of documents and notices is going to who's ever in line 39, or they were supposed to be going to you. Right, delivery address. I think it says the same thing here, right? Mail addressed to either party or to party recipient, line 38, 39. So they got a caveat, no matter what it is, it could go to the party or to the party's recipient for delivery, if named in 38 or 39. Actual receipt by a named buyer or seller constitutes personal delivery, or actual receipt by all buyer. Personal delivery to, or actual receipt by any named buyer or seller constitutes personal delivery to, or actual receipt by buyers and sellers. So actual receipt is when they actually give it to you. If I don't stop at the definition, that means they actually gave it to you. But personal delivery could mean they gave it to your agent. Occupancy of the entire property shall be given to buyer at time of closing. Actual receipt means that a party, not the party's recipient of delivery, if any, has the document or written notice physically in the party's possession regardless of the method of delivery. Well, they need to show that you've had actual receipt, right? And they always talk about having personal delivery. They don't talk about actual receipt, and personal delivery can go to an agent. On closing no later than at the place selected by the seller unless otherwise agreed by the parties in writing. Buyer is informed the actual real estate taxes for the year of the closing and subsequent years may be substantially different than from the amount used for proration, especially in transactions involving new construction, extensive rehabilitation, area-wide reassessment. Buyers encouraged to contact local assessor regarding possible tax changes. Property, unless otherwise stated, property means real estate in 4 and 7. Lines 4 to 7. If it's contingent on financing. So it's a pretty extensive form. I mean, did you sign one of these, people? You got a copy? Buyer and seller agree that a delivery of a copy of any written loan commitment to the seller, even if subject to conditions, shall satisfy buyer's financing contingency if after review of the loan commitment, buyer has directed in writing delivery of the loan commitment. Buyer's written direction shall accompany the loan commitment. Delivery shall not satisfy this contingency if accompanied by notice of unacceptability. Well, there. Now we're talking about documents and notices, which you didn't get. The delivered commitment may contain conditions buyer must yet satisfy to obligate the lender to provide the loan. Buyer's lender and agents or agents of buyer or seller shall not deliver a loan commitment to a seller or seller's agent without buyer's prior written approval or unless accompanied by a notice of unacceptability. So did your agent do all of these things? Because you have an agent. He's working for you. Distribution of information. Buyer and seller authorizes the agents of buyer and seller, right? The agents of buyer and seller to distribute copies of the offer to buyer's lender, appraisers, title insurance companies, and any other settlement service providers for the transaction as defined by the Real Estate Settlement Procedures Act. There's your RESPA. Who's responsible for it? Your broker is. Default. Seller and buyer each have a legal duty to use good faith and due diligence in completing the terms and conditions of this offer. But who's representing the buyer? We're talking about the broker has these duties. A material failure to perform an obligation under this offer is a default which may subject defaulting party to liability for damages or other legal remedies. That's what we're going after. Note, if accepted. This offer can create a legally enforceable contract. Well, why else do it? Okay, and then, hey, eventually they'll start talking about things to do with the title, right? So title evidence, conveyance of title. Upon payment of purchase price, seller shall convey the property by warranty deed, trustee deed to seller as a trust, personal representative, free and clear of all liens and encumbrances except municipal zoning agreements, recording, blah, 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 covenants, present uses of property in violation of foregoing disclosed in the seller's real estate condition report. And this offer, general taxes levied for a year closing and So there's a thing called a seller's real estate condition report that was supposed to be given to you to tell you what stuff is against the property. Right, this document and those documents, they're really your warranty deed, not that piece of paper we saw before. Doing these things is your warranty. Seller shall complete execute the documents necessary to record the conveyance at seller's cost and pay the Wisconsin real estate transfer fee. Right? The seller had to take care of transferring the title. And it ain't happened yet. Seller shall give evidence of title in the form of owner's policy of insurance in the amount of purchase price of the current ALTA form issued by insured license to write title insurance in Wisconsin. But who did he give it to? He gave it to the buyer's agent. That paperwork that you get from him is, it's camouflage. It's counterfeit. It doesn't have your name on it. If there was any real paper, it went to the broker. Seller shall pay all cost of providing title evidence to the buyer. Buyer shall pay all costs providing title evidence to buyer's lender. Gap endorsement. Seller shall provide a gap endorsement, which I think is what that warranty deed is that we saw in the property file, or equivalent gap coverage cost to provide coverage of any liens or encumbrances first filed for record after the effective date of the insurance commitment and before the deed is recorded. Because the deed hasn't been recorded yet. Right now, this is the deed. Signed, sealed, delivered. This would be the deed. It hasn't been recorded yet. Subject to the title insurance policy exclusions and exceptions, provided that the title company issue the endorsement. If a gap endorsement equivalent gap coverage is not available, buyer may give written notice. The title is not acceptable for closing. Right now, our agent may have done that, and we don't know anything about it. For purposes of closing, title evidence shall be acceptable if the required title insurance commitment is delivered to the buyer's attorney. Agent, did these things happen? Agent, I don't know. That's why I hired an agent. Subject only to liens of which will be paid out of proceeds of closing and standard title insurance requirements and exceptions as appropriate. So if there were any liens against your property before you took, control, they should have been paid off. Except when you look at, Schedule B, it talks about these liens that could still have not been of record and so forth. Well, then, they still had to be taken care of. If they weren't taken care of, then the seller didn't take care of cleaning up his act before he sold the property. He didn't give you a marketable title. Title not acceptable for closing. If a title is not acceptable for closing, buyer shall notify seller in writing of objections to the title at the time of closing in such event. And so, all right, so this is the paperwork. Broker's disbursement of earnest money does not determine the legal rights of the parties in relation to this offer. Buyer's or seller's legal right to earnest money cannot be determined by broker. At least 30 days prior to disbursement, broker shall send buyer or seller notice of disbursement by certified mail. Did you get that from your broker? Seller accepts this offer, right? Okay, so here we go. Now we got the buyer's signature. The seller accepts it. Boom, you got a contract. And I think that in here, it actually talks about the word warranty, that this is the warranty. Let's see if we can find it real quick. Upon payment of purchase price, seller convey the property by warranty deed. Yeah, we got that. It's the only place they talked about it. Must have been to somebody else's. All right, that was Wisconsin's. And in Wisconsin, they call it. All right, this is approved by the Wisconsin Department of Regulations and Licensing, which are the people that license real estate agents. So you would think this is the form they're using. And if you are in Wisconsin, whether you're in a foreclosure or you just own property, you want to call your broker and say, hey, I never got a copy of my WB11 residential offer to purchase. In fact, I may not have gotten some other paperwork. Can you send it to me? Let's see what they say. Mandatory use date. Hey, it was mandatory to use this after 7/1/11. In New York, they have, standard form contract for purchase and sale of real estate. So by whatever name it is, what did your agent use and where's your copy? And what other mail do you have for me? Notices and documents. Who the seller is, who the purchaser is. Did they use your full legal name? Property to be sold. Contingencies, title, a blank for your abstract of title tax search and any continuations thereof, or fee title insurance policy shall be obtained at the expense of somebody, right? Purchaser or seller. Could have both. Well, the seller shall cooperate in providing an available survey, abstract of title, or title insurance policy information without cost to purchaser. But who got the paperwork? The property shall be transferred from seller to purchaser by means of a warranty deed with a lien covenant or deed furnished by the seller. All right, by a warranty deed with lien covenant or deed furnished by the seller. And again, I'm going to say this is the deed. Writing under seal delivered is a deed. But it's used for contracts and conveyances. That's the simplest definition of deed. The deed and real property transfer gains tax affidavit, right? So now there's an affidavit someplace. So the deed and real property transfer gains tax affidavit will be properly prepared and signed so that it will be accepted for recording by the county clerk in the county in which the property is located. If the seller is transferring the property as an executor, administrator, trustee, committee, or conservator, the deed usually in such cases shall be acceptable. New York State transfer tax, additional tax, and mortgage satisfaction. The seller shall pay New York State real estate property tax imposed by this section of law, and further agrees to pay the expenses for procuring and recording satisfactions of any existing mortgages. Transfer of title. The transfer of title of the property from seller to purchaser shall take place at the office of the lender's attorney if the purchaser obtains a mortgage loan from a lending institution. Otherwise, the closing will be at the office of the attorney of the seller. The closing will be on or before some date. Possession shall be granted upon transfer of title unless mutually agreed upon in writing before signed by both parties. So if for some reason the transfer didn't happen, yet you took possession, then you may have possession, but you don't have rights, titles, and interest. You're just a squatter. Real estate broker and cooperating broker compensation. Well, there you are, right? If they got it, then they're involved. Condition of premises, inspections. Right? You got a purchaser and a seller, attorneys for purchaser and seller, agent. A lot of people sign this contract. They're all parties to the contract. Right? This says for informational purposes only or something like that, right? The following is for informational purposes only. It means who's going to get the information, right? Where are we sending the information to? We're going to send it to these people. So it doesn't really matter what state you're from. You need to contact your broker and tell them you want a copy of your frickin' buy-sell agreement or whatever they called it. Here's a Michigan one. Where it says, you got the selling office, selling realtor, listing office, listing realtor, property description. Well, don't even have your name on it. Where's the buyer? You haven't been even listed yet. Purchase price, method of payment, title insurance. Seller shall provide buyer at seller's expense an owner's policy of insurance with standard exceptions, the amount of purchase price. Well, where's it at? In your full legal name. Seller shall pay all state and county transfer taxes and costs required to convey clear title. Where's the receipt? Not just that it's been bought, that it's been transferred. Occupancy. Seller shall give occupancy as follows: after some days after 12 noon. So, obviously none of these are the same exactly, but they're doing the same thing. Somebody's acting as your agent. It isn't all done yet. Go to your agent and say, hey, well, I don't think we're quite finished yet. And your agent's going to say, oh, apparently there's been a mistake. And contact the seller. And if they won't fix it, well, then they'll mediate. And, you know, it'll go from being a mistake to being an omission, and somebody will pay with their insurance. So I really need somebody to go down and get theirs because I don't have one of these to look at, right? I mean, all I have are blanks. None of this is anybody's property file to look at. So go get yours and send me a copy. This is Florida. Purchase and sale agreement. Copyrighted and suggested for use by the members of the Northeast Florida Association of Realtors. If it's good for them, it's good for everybody. Buyer and purchaser. Right? Names as reflected on government issued ID and marital status if individuals. So that may be where a single man comes from, or an unmarried man, or whatever. But still, it has to have the name that's on the government issued photo ID. And in Florida, I do believe they use your full legal name on your driver's license. Property description. Again, I'm going to say, hey, street address. I mean, street address has its own definition. It isn't just where you live. It's the name of a broker account. Right? That's what I want. I want the broker account street address that they use. I'll go back and look at that again. The property will be conveyed by statutory general warranty deed, trustees, so forth and so on. Okay, well, it better be in full legal name. The title evidence of survey as specified below shows seller is vested in marketable title, including legal access and transaction. Legal access, right? The driveway permit has been executed. Otherwise, you wouldn't have access. Right? It means legal access to the right-of-way from the property. The transaction will be closed and the deed and other closing papers delivered on or before some date. Delivered to who? As we're seeing, it looks like it goes to the agent. If closing cannot occur by the date closing due to some reason, well then, you'd have to read it. Title evidence, at least so many days before closing. 10, if left blank, the party paying for the title insurance shall cause the title agent, we got another agent involved now, to issue title insurance commitment for the owner's policy in the amount of the purchase price and the title insurance commitment for mortgage policy in the amount of the buyer's loan if the buyer is financing the purchase. Well, where are they? And a survey. Prorations, property tax, buyer will pay, seller will pay, deed stamps and owner's title insurance. I don't see deed stamps up here, so they have to pay for them. There's title insurance endorsements, but not owner's title insurance policy. Seller does hereby represent that seller has legal authority and capacity to convey the property and that no other person or entity has ownership interest in the property. Well, that's a warranty. He represents that he has the authority to sell the property. That's what the warranty is, representing that you have the authority to sell the property. Is not now, will not prior to date closing, subject to a municipal or court or county code enforcement proceeding. Right? There's no liens or encumbrances waiting. I mean, these are quite lengthy documents. Buyer and seller acknowledge receipt of a copy of this agreement. Is that a fact? I have to call my brother-in-law, see if he's got one. You got one of these, Brian? You got your copy of this buy-sell agreement? Except for brokerage agreements, buyer and seller and broker agree that the terms of this agreement constitute the entire agreement between them. Okay, so the only addition would be the brokerage agreement between the buyer and the broker. Written notice to the broker for a party shall be deemed notice to that party. Well, that's all you need to see to say that you've agreed that all the paper can go to the broker. It doesn't have to go to the party. Broker is using this agreement is deemed to include all brokers, licensees licensed to sell real property in the state of Florida. Escrow. Agreed broker may place escrow funds in an interest-bearing account pursuant to rules and regulations of Florida Real Estate Commission and retain any interest earned as the cost associated with maintenance of said escrow. And I'm saying your property is still in escrow because it's never closed. All right, so you got all the money you've been paying in is going into an escrow account. And they're claiming the interest off the escrow account. But you could say, look, they don't want to lend me the money, give me back my escrow, they have to give it to you. Because the money has nothing to do with the title to the property. The seller who becomes the grantor on a warranty deed, he says he's been paid. So, that's good enough for me. Well, he's already been paid. It doesn't matter what anything else says. He's been paid. So give me back whatever's left. Date of acceptance. You got the buyer and you got the seller. And then you got a broker. Name a selling broker, name a listing broker. So who's this here? Maybe this is who's going to. Broker by signature below acknowledges receipt of some amount of money as the binder deposit specified in 1A of this agreement. It will be deposited and held in escrow pending disbursement according to the terms hereof, together with any additional binder deposits, right? Your monthly payments, escrowed by the terms of this agreement. And it's going to this company at this, that's where your money is, in this company. So go to your Realtor and get your damn buy-sell, Florida. Yours is pretty cut and dried. And we'll look at one last style. This is Illinois. And this style here, because Rosita had told me in her case that they didn't have a broker, right? They had two attorneys, an attorney for each party, at least that's what they thought, and then they went to a title company. But when you look at the title company's website, it says they can also do real estate functions or transactions or whatever. So they must have a real estate license. They're acting as the, that side of the business is acting as the broker. But, so whatever happened when Rosita went and challenged her closing agent that he was working for her, you said, no, I wasn't working. I wasn't representing you. Well, then who was? Your agent, who wasn't there. Purchaser agrees to purchase, right, in blank county, Illinois. Not county of blank county, Illinois. Right? Your property isn't in the county of Kane, Illinois. It's in Kane County, Illinois. Yet, a lot of the paperwork they show, especially for the courts and stuff, it says it's the county of Kane, Illinois. A different venue. So this is the venue it should be happening in, Kane County, Illinois, but that isn't the venue that your paperwork will show. Commonly known as on and on and on. This was pretty short and dry. You just got purchaser and seller with some additions. Seller shall deliver, cause to be delivered to purchaser or purchaser's agent. Title commitment for the owner's insurance policy issued by, in this case, Fidelity National Title Insurance Company, in the amount of the purchase price covering the title of real estate on or after the date thereof, on or after, not just on, but after. That would be now, right? This is after. Showing title is in the attended grantor, subject only to the general exceptions contained in this policy unless the real estate is improved with a single family dwelling. Yada, 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 yada. The title commitment shall be conclusive evidence of good title. So where is it? The title commitment discloses unpermitted exceptions. Seller shall pay the amount of any stamp tax imposed by state law on the transfer of the title and shall furnish a complete real estate transfer declaration signed by the seller or the seller's agent in the form required pursuant to Real Estate Transfer Tax Act of the State of Illinois. It shall furnish any declaration signed by the seller or seller's agent or meet other requirements as established by local ordinances with regard to transfer of or transaction tax. But it's going to go to your agent. The provisions of the Uniform Vendor and Purchase Risk Act of the State of Illinois shall be applicable to this contract. Well, okay, so by reference, they just included a whole other act that becomes part of this contract that they didn't put in here, but it all applies. Right? Uniform Vendor and Purchase Risk Act of the State of Illinois. At the election of the seller or purchaser upon notice to the other party, not less than 5 days prior to time of closing, the sale shall be closed through the escrow with Fidelity National Title Insurance Company. Well, did they do that? And where's the proof? And that's it. Right? So, again, these are just different styles of things going on. No matter what state you're in, if you bought a house, go to the real estate agent and ask them for your buy-sell agreement. Let's just start there. Right? We don't need to get it all figured out the first pull. Go get a copy, see what's on it. And while you're there, say, well, what else do you have? Do you have any other mail, any notices or correspondence that had anything to do with this agreement? All right, get all your mail, make a PDF and send it to me. Let's see what we got or what you got. And I got one other thing to share with you. Give me just a second. I'll go pull it up real quick. Okay, so on Monday, 2 days ago, it would have been the 14th, Dana Reed Smith had a court case, had a trial on this matter here, which was the 2 counts were assaulting, resisting, obstructing a police officer and controlled substance. One was a felony, the other one was a misdemeanor. Had to do with the police, the sheriff, so they say, although we've not seen their certificate that says that they actually are authorized to be a law enforcement officer. You know, again, they got to have a license from the state. It's called, here's from the Michigan Commission on Law Enforcement Standards, MCOLS. Issues a certificate to anyone who's passed the minimum standards to be considered a law enforcement officer, and then they can go, get a job as a law enforcement officer. Well, until you show me that card, you ain't a law enforcement officer. I don't care if you're driving around in a car that says sheriff on it. So they showed up at his house at midnight, broke down his door, kicked his dog, took him out and this was all because he had apparently missed a hearing for a misdemeanor. And they said they had an arrest warrant, but they didn't have an arrest warrant. And so anyways, on Monday, they had a jury trial, and they ended up with a hung jury. A hung jury or a deadlock jury is a judicial jury that cannot agree upon a verdict after extended deliberation and is unable to reach the required unanimity or supermajority. This situation can occur only in common law legal systems because civil law systems either do not use juries or at all or provide, that the defendant is automatically acquitted if the majority or supermajority required for conviction is not reached during a single solemn vote. Well, he should be acquitted, right? So what they're saying is, well, that the prosecution could bring this up again, right? But if you had followed what we have been doing in his case, well, I hadn't really talked about it here recently because we're waiting for things to happen. Not a lot had happened, but apparently either 8 or 4 or 9 or 3 of the jurors agreed with Dana that they didn't have an arrest warrant. Right? So all through this stuff, what Dana would be saying anytime he had to go is, I'm not here as a defendant. I'm here as a witness to a crime. These people weren't who they say they were. They broke down my door, They didn't have an arrest warrant. And so it's case 18-004207 FH40 Smith Dana. That's not his name, but hey, that's who they're charging. Right? You don't have commas in your name. They've already dismissed the marijuana, but at the beginning of the year, they got voted in anyways. So, now you can have up to 2.5 ounces of marijuana in Michigan. So, and it still shows the assault, although they said it was a hung jury, and we'll see what's going to happen. But Dana also, in all this, we found out that they have this form, right? Liability Claim Incident Report. So this is the risk management form you'd be looking for. He got this from the circuit court clerk, which is also the county clerk in Michigan, gave him this form completely blank. And it's from the Michigan Municipal Risk Management Authority. Well, municipal makes you think of, in Michigan, of townships and cities and villages, but not a county. A county is supposed to be an administrative arm of the state. It's not a municipality. So not really sure why he's getting it from her, but that's who he got it from. So he's filled it out and gave it back to her this week. I think he picked civil rights violation, personal injury, bodily injury, property damage, filled out what he could and took it back, and we'll see where that goes. Because it was a false arrest. Right? They didn't have an arrest warrant when they came out to his house. In fact, in court, they got asked that. There were 3 different cops, all got called to the stand. That was the first question that the attorney was asking about the arrest warrant, and they said they didn't have one. Must have been at the, dispatch or something like that. Anyways, hopefully Dana can get a transcript, and then I'll get him on the phone, and we'll go through the transcript, make a recording, and show the transcript at the same time, and we'll see what's going on. But Dana's happy as can be because, he was looking at a felony charge and, well, it was a hung jury. Now, what that shows you is that no matter what you do, you're never going to win in that court. What should have happened was they should have said, if they couldn't agree that it had been done right, then it hadn't been done right. And Dana should have been acquitted. And it could have been charges for false prosecution then. Because we had shown that the oath of office that the prosecuting attorney is using, he did it in his, middle initial name. And it was witnessed by somebody using a middle initial name. So really it isn't an oath of office to a constitutional office in the state of Michigan. It's a counterfeit certificate of a public security of the United States. Because they're claiming to have authority based on that piece of paper. And they don't. And so we'll see what they come up with. If what the insurance company has to say and what Dana comes up with. I don't think there's really anything else I needed to show. Just, hey, that's what happened on the 14th, 1/14/2019. After 14 months, the jury decided, hung jury. Right? And maybe they got the idea that the state of Michigan, county of Kalkaska, isn't the same as Kalkaska County, Michigan, and all the other things that have been pointed out. I don't really know what the jury got to see. But anyways, we'll try to get the transcript. Problem is, nobody has any money, right? We, the doers, don't have any money. That's why we're doing, because we really got to get a freaking remedy, right? And you that watch videos and don't have a problem are the watchers that you could be helping the common, the common good by donating, because we're really trying. All the shit will help you if it ever gets to you. The fact that you don't have a problem doesn't mean you won't have one next week, because they just pick you off one at a time. Pick, pick, pick. So please, if you can, my rent is 16 days past due. So in the name of the common good, please donate. I need you to help me out. I'm waiting for it to come, praying that it does. Other than that, you all have a great day, and we'll see what we find out next when somebody goes and gets their papers from the broker. We'll see what the broker has to say. Okay, have a good day. See you.